I just want to start. Perhaps the most famous example is of Lord Vishnu transforming into Mohini, the women version. We have heard the stories of Samudra Manthan, how Lord Vishnu in the form of Mohini distracted the Asuras. We have heard the story of how Mohini tricked Brahmasura, the demon, to destroy himself. We have heard the story of how Lord Vishnu in the form of Mohini formed the union with Lord Shiva. We have also heard the story of how Arjuna as Brihanala, as a female dancer. We have also heard the story of King Ila, who married Buddha. We have also heard the story of Arjuna and Nagkanya Ulupi, who united together and produced a child called Arvan. And just not to die single, Vishnuji again took the form of Mohini to get married. I want to narrate one important issue in this country, the important situation in this country. In the state of Tamil Nadu itself, the Kuthavandawar temple, I don't know if my Tamilian friends, if I've got it right or not, in Viluppuram district has built a temple for Aravan, who was a transgender. People all over the country do visit, even from abroad, even from Japan, people do visit this transgender, the temple created for a transgender. Honorable Speaker Sir, Speaker Madam, I rise today to speak on a matter that is not merely legislative, but deeply constitutional, moral, and civilizational. The bill before this House seeks to amend the Transgender Person Protection of Rights Act 2019. At first glance, the government presents this amendment as an administrative correction, but when we read the provisions carefully, it becomes evident that the bill risks rolling back the hard-won constitutional rights of one of the most marginalized communities of our country, the transgender community. Let me state clearly, this debate is not about just ideology. It is about the Constitution of India and the dignity of human beings. Honorable Chairperson Madam, in National Legal Services Authority versus Union of India, popularly known as the Nalsa judgment, the Honorable Supreme Court delivered a historic verdict stating that the court held that the transgender person must be recognized as a third gender and enjoy full constitutional protection under Articles 14, 19 and 21. Most importantly, the court recognized the right to self-identification of gender and held that the gender identity is an intrinsic part of human dignity and personal liberty. The court explicitly stated that no person should be forced to undergo medical tests or procedures to prove their gender identity. Yet, this amendment bill now proposes a system where identity must effectively be validated through medical authorities and administrative certification. I ask the government respectfully, are we legislating against the spirit of our own Supreme Court? Time and again, the government circumvents the Supreme Court's decisions. Sometimes even contempt of order, contempt of court has been committed. Honorable Chairperson Madam, the Constitution does not grant dignity through a certificate. The Constitution recognizes dignity because a person exists. Article 14 speaks of equality before the law. Article 19 guarantees freedom of expression. Article 21 protects life and personal liberty. In Nalsa judgment, the Supreme Court interpreted these provisions to include the freedom to express one's gender identity. Gender identity, the court said, I quote, open quote, an innate perception of one's gender, close quote. By narrowing the definition of transgender persons, and placing the identity under bureaucratic verification, this amendment risks transforming a constitutional right into administrative privilege. Honorable Chairperson Madam, India has historically been a civilization that recognizes diversity. Across the world, courts and democracies are increasingly recognizing gender identity as a matter of human rights and personal autonomy. Countries such as Argentina, Malta, Ireland, Denmark have enacted self-identification laws where gender recognition is based on person's declaration rather than medical verification. The Yogya Karta principles, widely recognized in international human rights law, affirm that gender identity is a part of right to dignity, privacy, and self-determination. India, through the Nalsa judgment, only 5 minutes have been up. I think my party has guaranteed me more time. Kindly just let me cover the important points, madam. Though through the Nalsa judgment, was once again the leader of Global South in recognizing transgender rights. Today, through this amendment, we risk moving backwards. The transgender community in India suffered centuries of discrimination, whether it is in the sector of education, health, employment, housing, dignity. The Honorable Supreme Court acknowledged this history and recognized transgender persons as socially and educationally backward, recommending affirmative action for them. The purpose of the 2019 Act was to remove barriers, but instead of removing barriers, this amendment risks creating new ones. As per 2011 census, only 4.9 lakh transgender community were recognized, but that was underreported. I want to ask a fundamental question. If the state begins to decide who qualifies as a legitimate identity, where does it stop? Tomorrow the state will decide who is legitimately religious, who is legitimately tribal, who is legitimately belonging to a particular caste. Identity cannot be certified by a state. Identity is a part of human existence. I just want to make one Supreme Court judgment. In the Jain Kaushik case, the Supreme Court established that expert committee should be established for regarding the harassment of trans people. The Supreme Court established that expert committee should have been established. Without establishing the expert committee, this bill should not have been introduced. What is the malice for introducing it? That needs to be clarified by the government. Therefore, the opposition is not against reform. We are not against strengthening the penalties for crime against transgender persons. The fact is that we want a stronger law. Do not dilute the principle of self-identification. Ensure the administrative process facilitate identity recognition and not police it. Consult transgender communities, the stakeholders in this, and the civil society before passing such amendments, and uphold the spirit of the Constitution and the landmark Nalsa judgment. Thank you, Chair.